All rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time and date set for cause number CV 230264, Carter versus BNSF Railway. These proceedings are being video and audio recorded as well as live streamed, so I ask you to please introduce yourself and your client at the beginning of your presentation. Each side will be responsible for maintaining their time. You'll have 20 minutes each. If you care to reserve any of that for rebuttal, that's up to you, Mr. Abney. We have read the briefs. We've discussed this case in conference. We are familiar with the facts. Please bear that in mind during your presentation. And at this point, Mr. Abney, if you're ready.
I'm never ready, Your Honor, but I'll try.
I thought you were born ready, but okay.
I used to say that, but I couldn't figure out what it meant. I was born wanting to get fed, I think. This case is a good example of how there's no uninteresting area of the law if you just delve into it deeply enough. I'd never really heard of the Locomotive Inspection Act other than some echoes of history classes I took concerning the Progressive era. It was a response to rapid industrialization and the lack of care in the railroad industry, which was incredibly important at the time. There was no interstate highway system. There was really no other way to move goods around other than by the railroad, and they were moving goods in massive quantities, and workers were suffering massive injuries as a result of not getting compensated properly. So Congress came up with the Boiler Inspection Act, which became the Locomotive Inspection Act, and then a number of other acts that were very similar in wording and intent. The idea being that if the locomotive and its appurtenances and the railroad cars were defective in any way and caused injury, well, you'd have a recovery. A very good system. It's one that the courts have said is supposed to be construed liberally to carry out its remedial and humanitarian purposes and to guard workers against harm by defective railroad equipment.
But you agree that strict liability does not apply if it's not in use?
Right. It needs to be in use under the Locomotive Inspection Act. But in use is not what you would really think. If you go back to Brady's a great example. The 1938 case, we had a car inspector who grabbed it was going up a side ladder. He grabbed what's called a grab iron, and it pulled out. The wood was defective, rotten.
But in Brady, it was a non-defective car. Is that right?
No, it was defective. The grab iron was defective. The wood holding it was
being inspected, though. It wasn't taken someplace for repairs.
No, it was no place. It was no place for repairs. It was waiting to be accepted to continue on. It was when a string of cars waiting to be accepted to continue on its journey. It was considered to be in use, even though it hadn't been inspected. And it was absolutely motionless because it was going to be put into active movement.
If it had been taken to a repair facility, are you saying the same result? That someone had noticed something wrong with it, takes it to a repair facility, would it have been in use under Brady?
If it had been very briefly subject to delay because of inspection, it would still be considered to be in use. If it's taken to a repair facility and just left there, and people are really going to actually repair it, then probably would be considered to be not in use. But that's not what happened here. It was merely put on the siding for a brief inspection and checkup.
But it's put in the bad order spot. That doesn't count in your mind as a repair facility?
No, it doesn't. And in fact, the avowal at the trial court in the transcript by the counsel for BNSF was that actually was checked and then went on its way. So there was really no delay at all. I mean, and this was an active process that was going on, even though it was motionless at the time.
But I guess my question, though, are you saying there's a difference between a bad order spot and a repair facility?
Yes. Yeah, huge difference.
But couldn't you make the same argument? It went to a repair facility, they looked, it went on its way. 5 minutes later, you're saying it would still have been in use?
Under those facts, it would be. Under those, but you have really defined it being in use. It's very briefly looked at, and it's on its way.
So, Mr. Abney, if it's not in for repair or being repaired, anytime the locomotive is moved, it's in use? under your definition?
Well, sure, movement helps, but it doesn't have to be moving. In Brady, it was absolutely motionless. It had just been sitting there. And the inspector came along, grabbed the ladder, the portion of the ladder, it gave way, fell, hurt himself, and the court said it's still considered in use.
If that's the case, why is in use such a kind of pivotal inquiry in this kind of a matter? If it could be stationary, it could be moving. The only thing it can't be is in a repair facility to take it out of the in use. How does that make any sense? With all the case law that we have interpreting what does in use mean?
That is the essence of the case law. If it's simply temporarily stopped and it's going to be on its journey, then it's considered to be in use. And here, there was just a temporary
Does it matter
stop.
that they noticed that there seems to be an oil leak?
Right.
And that's the reason for taking it to a bad order spot that's marked on the tracks, apparently
putting
blue
it-
paint, whatever. But someone actually notices and says,
Right.
this appears to need a repair. That seems different than just, we're going to have a routine inspection, and during a routine inspection, that's just going to take a couple of minutes before you go on the way, someone falls, or there's a defective ladder. This seems like we know there's a problem with this, or at least someone thinks there is, takes it to a repair facility if we buy that a bad order spot is the same as a repair facility. If I could just ask you, assume at least I think a bad order spot is the same as a repair facility.
Right.
If it goes there, how long does it have to be there to be out of use?
A matter of minutes or hours is what the case law says, which is apparently fits here perfectly. If it's there for a matter of minutes or hours and then continues on its way, it's still considered to be in use. If it's there long-term at a real repair facility, then it's considered to be out of use. But that's not what happened here at all. There's so many cases because it's really difficult to grab a hold of what in use means.
What's in the record that says that this train went on, that what was required to fix it, and when it went on, and what happened?
We have very little on that. We have an avowal from the counsel for BNSF, and I think I mentioned that at page 60 of the opening brief, that he said it was BNF decided to go ahead and use locomotive BNSF 544. It was not taken out of service, just used by another crew since Carter had been injured. So they got another crew, and then it went on its way. That's what we have. It's simply an avowal on the record. If I had been there, we'd have had a better record, but that's what we got.
That's just part of the hearing transcript. That wasn't
Right.
part of the undisputed facts that were submitted with the summary judgment motion.
No. It was simply an avowal by counsel, which I think should satisfy for this particular circumstance of what actually happened with the locomotive. But simply being temporarily on a siding, that doesn't take a locomotive
Let me ask
out
you
of
about
use.
that. If the summary judgment motion was decided, I mean, it's just submitted based on undisputed facts, and that goes to my question about whether we need a transcript, whether the transcript is significant. If it's just argument of counsel.
I think there's a difference between an argument of counsel and an avowal by
And so
counsel.
you're saying this was, he's making a statement, I'm avowing that this is what happened?
No, most lawyers are not that formal. Sometimes you get that way and want to be formal, but this is simply a statement made to the court. But I think, as a lawyer, you can't just lip off to the court and say whatever you want. Your words have weight and consequence always. And if you're telling the court, well, this really just went on its way, that
We
matters.
usually don't say the argument of counsel is usually not viewed as evidence.
No, it's not evidence, but by golly, why do you get to say one thing and then come up on appeal and say, well, we didn't mean it,
Why
it's
wouldn't
not
your
for the
client
record.
in responding to a motion for summary judgment, isn't it incumbent on who's ever responding to say these facts are important, or these facts are disputed, or here's some different facts that need to be considered?
That's what you should do. And sometimes you in the haste of the moment, you don't realize you haven't done what you should do. But if you go into court and make statements to the court about what happened, it matters, and it's something that a court should think about. But even if that avowal had not been made, all you have is this engine off to the side. You've also got some very interesting testimony by Carter, and I'm sure that's in the record, saying, well, I wasn't finished. Number one, I am not an official inspector. I am an engineer. I do a visual inspection just the way a pilot and you may have noticed this.
Could I ask you, sorry, before you get there, was Carter finished shutting down the train?
No, or I said a categorical no. Or if you look at the evidence in a slightly different way, he's not. He never released. He never says I shut it down. I distinctly remember saying this. He's saying I don't really remember if I shut it down or not.
But it seemed to me, at least my recollection was that he thought maybe he didn't do it, but someone else had shut it down. He thought it was shut down. He thought he had done what was necessary. That whatever needed to be done, he was no longer required to do something to keep the train from moving. Is that
I don't
not
think
accurate?
that's exactly accurate. It was more. He said, and I went over this in the opening brief at page 62. He was doing a release test, which involves knocking off the air for the air brakes, making sure the manual brake is holding, reapplying the air independently, temporarily shutting down BNSF 5440, and then he was going to move locomotive BNSF 7210. He did not set the derail device, which is important as far as shutting everything down, because as the name implies, the derail device derails, stops the locomotive in case it starts moving. So he wasn't finished, and he wasn't finished with BNSF 5440. In another sense, he was going to get the other locomotive, and then he was going to be in the process of making sure that they were connected end to end. So he wasn't done by any means with what he was going to be doing there.
But was he done from the standpoint of thinking that this train cannot be used until it's inspected, and it won't be moved from where it is right now until it's inspected? Is that a fair characterization of his view? No. Because
since he is not the inspector, he's not the one that can shut this down and say, hold it right here, it's got to be inspected. No. He simply called in and reported the situation and wanted somebody to come out to take a look at it. It's not something he can do. But he was not completely finished. The reason he was hurt was that he was not finished with the locomotive. He was leaving, he was going to get the other locomotive, he was going to make sure that everything was absolutely completely shut down.
Well, I get that he's leaving, but is he planning to move the train before something else happens?
I'm going to ask you to stop, and can you pause the timer, please? I don't know what that is, but it is getting worse, and it is very distracting. Dominic, can you go see if they are, whatever they're doing, get them to stop? And let's just give it a minute, sorry.
And sorry
It
to
sounds like
derail
a
you.
weed whacker.
I'll let you go back to what you were.
You haven't derailed, no pun intended, I'm sure, on your part, but you haven't derailed me. I enjoy a conversation, always.
All right, let's see if do you want to wait to see if it gets stopped?
I think it stopped. They must have sensed that he's on his way.
Okay. All right, Mr. Abney, go ahead.
Reminded me of being in the dental office. No, he wasn't done. And the one thing that comes out in the cases from way back in the early of the 20th century forward is how complicated locomotives and railroad cars are. There is always a process for getting them started, shutting them down, and he was not finished with his process when this happened. So on that basis, the locomotive was in use. It's also in use under Brady. I mean, Brady couldn't be a better case for me.
So, Mr. Abney, I just want to go back. You've talked a lot about the case law here.
Yes.
You've not mentioned the regulations that are in place.
No.
I mean, this act was put in place to make sure that, the railroad was safe for the workers. I think you've already touched on that. But in the regulations, it talks about the fact that a locomotive shouldn't be put in use until the inspection is completed for the purpose of safety and application of the act.
Right.
Your client, my understanding, admitted that he had not completed the inspection yet. So how can we find under the CFRs that it was in use when the proper steps had not been taken to get to the application of the strict liability standard?
The regulations surprise me in a way because they don't really come up very often in the case law. The cases start leap in about in use and discuss in use along the Brady guidelines that I've been talking about.
Doesn't that seem to be a problem that they don't discuss the regulations?
No, I think that the
Doesn't that indicate that maybe the court's just, making up a standard when there's already one in the regulations?
Well, they're following a standard that's been set by the United States Supreme Court back in the early 20th century, and especially in Brady and going forward. That's the standard that they're following. Is it in use or not is really a judicial decision based upon a huge body of case law. And I meant to start out by saying that I wasn't sure I really needed oral argument because I think the opening brief and the reply brief are some of the best I've ever done. And I was very careful in the reply brief to address every single case, 44 cases they raised in the answer brief, every single one. I talked about each one and distinguished it, discussed it, some longer, some shorter, but always there was that discussion. But under the circumstances of this case, the locomotive would be considered to be used under Brady and all the other cases before and after that follow the same sort of reasoning. He wasn't finished with the locomotive.
But my understanding is that the case law talks about a very fact-specific scenario. So I don't think we can look at every case and say, this says it's in use, this says it's not. We have to look at the facts of the actual case and what is going on, which I think is what we're trying to discern right now.
Right, in the light of general principles as developed by the case law. And the general principles are that even if it's motionless, even if it's on a siding, and even if nobody is actively doing anything at the moment, it can still be considered to be in use if it's off the main track for a period of minutes or hours.
So then my question is, when do the regulations even come into play?
I'm not sure they come into play for this particular situation.
So we're not supposed to look at the regulations at all as to what the railroad is. I mean, that's the standard that the railroad is held to, is what's in the CFRs.
That's one of the standards. The other standard is what's in the case law. I think this is a judicial decision more than anything else.
But courts get it wrong all the time.
Well, not this court, but other courts do.
Well, I would agree with you. We don't get it wrong, but
Unless the
anyway.
Supreme Court says you do, you're fine. Yeah.
But what I'm getting at is that we have a whole body of case law that is in some ways almost disregarding what is in the CFRs.
Well, it's a parallel track, and that was intended as a pun, but the regulations, I think, are important in the sense of this oil business. They say you can't have oil there, or other substances are going to be slippery. You have a defective vehicle.
So they apply when they help your client, and they don't apply when they don't?
Of course, Your Honor, but...
Thank you.
But is there something to the notion?
I didn't mean that.
No,
Is there something in the notion that we're not going to impose strict liability when it's in a repair facility? We want the railroads to be repairing the trains, and that's just that's different than just we're protecting the workers when the trains are in use. But normal principles of negligence apply once we're in a repair facility working on a defective train. We're not going to impose strict liability.
If it's not considered to be in use under the Locomotive Inspection Act, then you have liability under the FELA, and everybody agrees that this case goes forward would go forward under a negligence theory. Probably a pretty good case for negligence if there's a whole bunch of oil there and nobody understands where it came from. I mean, he didn't put it there, so there's going to be liability. He has to move around. But that's a different inquiry after this court is finished. But based upon the case law, this is one of those cases, a Brady case, where the locomotive should be considered to be in use. I will sit down, if I may, and contemplate the regulations. Maybe I have more comments on that.
Thank you, Mr. Abdi.
Thank you, Your Honor.
Ms. Freeman.
Good morning, Your Honor. Susan Freeman on behalf of BNSF Railway Company. Judge Hillfaster, let me start with you. The arguments with respect to the regulations are important. There are part 2 of our argument, that it never started in use in the first place because it had to undergo its daily inspection. And in the daily inspection, if anything showed up that was a nonconformity, and oil all over the walkway that was a possible slip hazard as a nonconformity, had to be repaired before the engine could be put into use. And there are cases like Lyle and Maynard, and we've cited all those in our part 2 of our argument, that in fact it was not put into use in the first place. Carter did the right thing. He started the daily inspection. He saw this nonconformity. He said, put it on the bad order spot, which, as Mr. Wood avowed in his declaration, and also as Mr. Carter said in his testimony, was a place for inspection and repair. And that was the place where the repair trucks could come up and actually access the train in a way that they couldn't otherwise. And so that's where it was, so that it could be repaired.
So can you explain to me then, under the regulations, when you believe the strict liability applies, So does it not take effect until after the inspection happens, after, all of this has happened, which could take hours, I'm guessing? And at that point, there's no strict liability under the regulation.
And until that has happened, until the repair has happened, and that's the whole purpose of the statute, this part of the statute, the no strict liability. It's to encourage them to go
Can
and
you
inspect and
explain
repair
that?
first.
I mean, to Mr. Abney's point, we have a whole body of case law that says the opposite. So,
If I may, Your Honor, it doesn't say the opposite. It deals with a situation where a train is already in use. It doesn't really come into effect here unless the court determines that moving it from the place where it was parked initially onto the Y, where it's to be turned around so that they can actually put a train together and get started, and then moving it onto the bad order spot, if that is use, and I don't think it is under the regulations, but if that is considered use,
but under
then
case
Brady
law,
applies.
some of that is in use.
I'm sorry?
Under case law, some of that is in use.
To actually be moving it, but the question is moving it for the purpose of setting up a train to actually start it before the daily inspection is done, that may not be in use. But if it is, then we get to the Brady line of cases, and I would urge the court to look at the Hooven case, which is the one that is cited in Brady for the point that if it has reached a place of repair, then it is not in use. Hooven is one where the Supreme Court said it was temporarily withdrawn from service and undergoing minor repairs. So it's maybe very temporary, may not need much of the way of repairs, for early return to service. And in Hooven, the court said a car at rest at the repair point is not within the statute. We certainly have the car at rest here. Whether or not it was actually shut down does not mean that it wasn't parked. Objectively, it was parked. It was completely stopped. He had gone out and set the repair brake, then came back in, tested it to make sure that it had worked. It was stopped objectively. We think that it was also shut down, that this was not just hypothetically, this is how I would ordinarily do it, but he was talking about what happened in this instance. I would point the court to another part of the transcript that I'm sorry I missed when working on the brief, but found it when I was preparing for this oral argument in Mr. Carter's deposition at page 78, lines 12 to 14. He says, the way the grade was, I guess when I turned it off, it stopped pumping the oil all over and the oil ran back to the center. I mean, he recognized that he turned it off, and that's when the oil started running down and off of the platform. He also testified back at 48 that this was oil all over the place because an injector fell out of a cabinet. Now, it may be very minor repair that you just need to screw that injector back in and then turn on the engine again and see that, all right, it's all fixed. Maybe it was something more than that. Maybe the injector stripped out and they can't get it back in or something. We don't know. There's no evidence in this record as to whether this was temporary or long-term. And there's nothing in the case law that says it had to be a long period of time. That's just made up. It's not there. There are a number of cases. Hooven is one. Estes is another 2-hour call. Compton, temporary repairs. Bruno, minor repair, but couldn't release until it was done. I mean, it doesn't have to be hours and hours before it turns into a situation where it is not in use.
I could just go back to the question before. If on the way to the repair facility, there's a problem and someone is injured, would you agree that that's still in use? It's just on the way to the repair facility?
Yes, there are some specific regulations about that we didn't address here because it was objectively stopped.
It was at the bad order spot, the repair facility.
Right.
Can we address that? Mr. Abney says the bad order spot is not a repair facility, and you would agree there is no repair facility at this location.
that is, no, Your Honor, respectfully, I would say that is the repair facility at this location. It doesn't have to be a roundhouse. There was no actual building for repairs in the Kingman-Berry area. I would point the court to other cases like Steer, where they had an asparagus patch, was what they called it, and Wright, they called it the RIP track, the repair in place track. This is not uncommon that you would have places in our entire country where you don't have an actual repair building, and so there are places where there's a separate track, and that is the evidence in this case. That is Mr. Wood's declaration, and as I said, Mr. Carter even testified that this was the place where you would take something for inspection and repair. That's where the maintenance trucks were able to drive up right next to it and do the maintenance on the engines that needed to be repaired. So that's the evidence in this case. It was stopped there, it was parked there. There was a nonconformity. There was oil all over. It had to be fixed before this could go forward. The oil had to be cleaned up. It had to be fixed. That's what the regulations say before it could be used. Even if it was used before, it had to be fixed before they could continue to use it.
And it was clear that the oil was coming from this train. I mean, let's say there'd just been an inspection and there's absolutely nothing wrong with the train and you just noticed some oil. Would that make a difference to the analysis?
Your Honor, if it was already in use as it's going along on the main line, then we don't have the initial regulations about needing to have a daily inspection and repair before it can be put into use. We would instead be just in the Brady situation. If it is something that is imperiling life and limb, then my understanding is that it needs to be pulled over onto a side track and repaired before it can go on. But just a little bit of oil, to my understanding, that does not. But again, that's not our situation. We have here that it was put on the bad order spot. We don't know whether it was blue flagged or not. It was a place with a little, blue marking so that you could do that. But the evidence in this case does not include whether or not all of the steps were taken to actually blue flag it or blue signal it. But what we do have is it was put there, it was parked. The fact that there was a nonconformity, the nonconformity that he said hurt him, that it had reached a place of repair, stopped, handbrake set, objectively parked, not in active service that morning, that's all we really need to fit within the statute and within the cases.
So Mr. Abney talked about the subsequent processing of it and that it was back in use shortly thereafter. Does that have any bearing on your argument, your analysis?
Your Honor, that is not the evidence before the court. There is no evidence with respect to how long it took to repair. Ms. McFall is here. She's the one who made that argument below and is in this transcript. She did not make any avowal to the court. And certainly what she said does not say anything about whether it was temporary.
Hold on.
I'm sorry.
Hypothetically speaking, let's accept the fact that later on that afternoon, they wiped up the oil, they replaced the thing, and off goes the train. Does that have any bearing on our analysis in this case if we accept your version of how we should decide it?
No, Your Honor, it does not. Okay. Because it doesn't matter whether it was temporary. Yes, it was apparently, they did repair the condition that caused the daily inspection, that caused it to fail the daily inspection required by the Locomotive Inspection Act.
Well,
That's what she said.
That it could have been as simple as turning something. That would be a repair.
We don't know.
Yeah, and that makes complete sense. I guess that what I'm curious about is if absolutely nothing is required and it was just oil that was from something else, but that it's not in the record. I guess your point is simply that it doesn't matter the short period of time.
Right. Whether it's short period or whether it's long period.
Was noticed and said this can't go forward until this is taken care of.
Exactly. Exactly. And that's all we need. Let's see. One other point I wanted to make sure that I covered, and that's that in the various arguments that were made especially in the reply brief, Mr. Carter is saying, well, it wasn't in use because I was not in a position to order it taken out of service, and therefore it wasn't, I couldn't decide whether it needed to be taken out of service. Only a mechanical person, only a repair person could do that. There's a difference between in use and in service. In use is a legal determination made by the court, made by the judge, not by the jury, but in use is a legal determination made by the court. In service is an operational term that is used by each particular railroad. It's what's within the course and scope of that railroad's own railroad operations and operating manuals and so forth. That would take discovery, investigation, maybe it would be something, but it doesn't matter for the court.
Can you point us to a regulation or case law that makes that distinction?
No regulations, nothing I could find that made that. I could tell the court that in the 1911 Boiler Inspection Act, I found a reference to in service, but that was taken out in 1994 when the statute was recodified as being surplusage because in service was not relevant. What mattered is in use, and in use is the question of law for the court. We've made the arguments already in our briefs with respect to the transcript not being appropriate for the court to consider. It was not before the court here, filed on a timely basis, and even if it was, the arguments that were made by counsel are not evidence, as the court noted, and to the extent that anything was said, nothing is said about the timing, just said that they did remedy the condition that caused it. So they repaired it. That's a good thing before the engine went on its way. Supplemental motion to revise. If the court has any questions about that, it obviously was not a timely Rule 59 motion, was not appealed. The decision on that, it was treated as a motion for reconsideration, and the court just determined that there were no issues of no new facts or law that would.
So let me ask you this. There was conflicting testimony about whether or not the engine was running or was completely turned off.
Right.
Does that have any bearing on your argument?
I think not, Your Honor. First, that was not raised below in the response to the summary judgment motion as an issue of material fact that needed to be addressed. So it wasn't addressed, but it was that argument was waived below, would be number one. Okay. Number two is that it really doesn't matter under the case law whether it was turned off or not. And I would cite the court to cases like Hooven that are saying, it was temporarily withdrawn from service, undergoing minor repairs, at rest in the repair point, not saying it had to be completely shut down. Number three, I would point the court to the fact that the trial judge is the one that is evaluating this, and the trial judge is the one who decides the facts. At most, I guess, if the court determined that really is relevant, you would, send it back for the trial judge to listen to the testimony on that particular point and rule on that fact. But the court ruled on that. And then number three, I would point the court to the additional part of the deposition testimony that I overlooked in the first place about when Carter turned the engine off, it stopped pumping the oil, and therefore it had started to run down off of the walkway, and then they were able to, determine, I guess he was able to get off. There's nothing that requires that it be shut down. Objectively, it was parked, and that's all that it takes. But we think that it was shut down as well. Let's see, what was the last point? That a safe exit. That to the extent that any issue comes up with respect to he should be entitled to walk off the engine, even though there was oil on it, the oil was draining down and causing, less of a slip hazard to the extent that there was a slip hazard in the first place. That's the way the walkways are made up. But he didn't walk off the nose of the engine where he could have gotten off of the engine altogether without having to walk through oil for a third time.
Counsel, how would this situation change if the first time he got on that locomotive, there was a pool of oil and he slipped as he's getting on it? How would this situation change? Would it change at all?
Saying getting on or getting off?
Getting on.
Getting on it in the first place, Your Honor, I think it would not under the regulations that we addressed in the first place, because he would be getting on for purposes of doing the daily inspection. That doesn't mean he doesn't have a negligence cause of action. He would have a negligence cause of action, just not negligence per se, because the whole point of the regulations in the statute is to enable there to be an inspection and repair before the engine goes into use. But again, that's not our case, and to the extent that he thought that there was any, real danger, he could have gotten off the nose where he wouldn't have had to walk through the oil, and he could have waited for the repair people to arrive. And they would help him get off in a safe manner. But he didn't do either. He chose to walk back through the oil, and he slipped. But so he has a negligence cause of action, just not negligence per se, because the engine was not in use at the point in time that he slipped.
So then my question is, could a person in Carter's position ever have a negligence per se issue? Or claim?
When an engine has reached a place of repair, then no. When an engine has not been cleared for use in the first place by not having passed the inspection, which is required under 49 U.S.C. 20701, it has to have been inspected as required under this chapter in regulations before a railroad may use or allow to be used.
So negligence per se could never come into play while they're putting two cars together, say, to do an inspection.
And there's a difference, Your Honor, between a daily inspection and a pre-use inspection. If these cars are kind of coming together because they have been used on a railroad line, and so one is coming one way, one is coming another, they need to pick up a car and connect it to another engine. It hasn't been sitting there overnight before a daily inspection, then there are different regulations. It's possible that you might have that kind of a situation where it's already in use and it's continuing in use. They're just recoupling one car to another. It's in use on the railroad line. That's not our situation here, where the daily inspection has not been started, or the daily inspection started, found a nonconformity, and then sent it off to be further inspected and repaired by the repair people.
Thank you.
Any other questions from the court? Okay, thank you, Your Honors.
Thank you, counsel.
I think the fundamental trouble with the regulations is the railroad violated them before anything got started and put the locomotive into use.
But wasn't that part of Carter's job?
His job was to get the locomotive 5440 matched up with locomotive 720.
My point is when you
Which is
say
what he
the
was doing.
railroad
Right.
was getting it put in use, isn't that Carter who's doing that?
Well, as a representative of the railroad, yeah, he's doing that. But then he is for that purpose the railroad. But
Okay,
on
thank you.
page 60 of the page 59 of the opening brief, I cite the transcript, and I think arguments, what you say to the court matters, and you're doing a motion for summary judgment, we have an argument. It's not just that you can go there and give a speech, you're communicating things to the court. And this is what the lawyer said for BNSF, quote, "When Mr. Carter moved the 5440 to that turnaround track, he placed it in use." He placed it in use. That's what the railroad itself is telling you. And that's what he was doing, as a matter of fact. He was putting it into use. He moved it over to the Y, and then when this oil condition became evident, moved it off to the blue dot spot for somebody to take a look at it. It wasn't going to be him doing the official looking. He's not qualified to do that. But it was there, just going to be there a very short period of time. Under Brady, the fact that it was motionless and it was off on its side and somebody was going to be inspecting it, it's still considered to be in use when a person is injured in the course
You
of
said
that process.
the railroad violated the regs. What are you saying the violation was?
Well, if the regulations say you can't put the locomotive into use until it's been fully and properly inspected, they put it into use already. They moved it to the Y. It was in use at that time. So the railroad violated the regulation.
The injury doesn't happen until after it's moved, right?
Right. It's after it's gone into use. It's in use when he moves it. He moves it to the Y, then he moves it to another spot. It's still in use. It hasn't been taken out
So
of use.
you take it to a repair facility. You're saying he's moving it and it's now parked at the repair facility and now a complete repair facility, no question about bad order spot.
Right.
It's still in use once you get to the repair facility?
You get to the repair facility, you shut it down, you're done, and it should be considered to be out of use. But I think the law logically would allow you a chance to get off the darn thing. If you park it and turn it off and you're walking off and there you go, I think that would still be within the penumbra of being in use until you get clear of the darn thing, which he didn't do. He was moving over to complete the next step in the process of assembling the train, and then he was going to go back to 5440, make sure everything got made up properly, and off they would go. And if he hadn't been hurt, that's what would have happened. But unfortunately, he got hurt, and that didn't happen. There was the equivalent of a motion for reconsideration. It was considered by the court. Argument was taken on it. It was, so it was. That's part of what you can consider on review, whatever was offered connecting with that. There's conflict.
The court didn't order a response, did it, on the, did the court order a response to the factual assertions made in the motion to?
I couldn't tell you.
It's called something other than a motion to reconsider. Motion to revise, I think.
I do remember the court said it was considering it and decided not to go that way. So I think once you consider it, it becomes part of the record on review for an appeal. And I've got 1 second. Thank you so much for your time. I appreciate it.
Council, thank you both for your arguments. Interesting issue. We will take this matter under advisement, issuing a written ruling in due course. We will now take a brief recess to reset the courtroom.
Thank you, Your Honor.